Ready? In order to ascertain the correct state of affairs, this court, by its order dated January 16, 1986, requested the District Judge Kanpur Nagar to inquire as to whether the state government has in fact implemented the social welfare measures in the district of Kanpur and whether such measures were adequate to meet the needs of the people. The learned district judge was asked to submit a report to this court. It was further directed by this court that the learned district judge, while preparing his report, would consider the feasibility of the implementation of some suggestions made by the petitioners regarding the steps to be taken for the purpose of ameliorating the condition of the people in the said district. The learned district judge has since submitted his report. The petitioners are not at all satisfied with the said report of the learned district judge. They have challenged the correctness of facts found by him, particularly with regard to the question of starvation deaths. It has been stated by the learned district judge, and there was hardly any case of starvation death. On the other hand, there has been implementation by the government of the social welfare measures. We do not think it necessary to consider the report of the learned district judge. It is agreed by the parties, including the petitioner number 1, who has appeared before us in person, that some steps should be taken for the purpose of alleviating the miseries and sorrows of the poor inhabitants. It is not disputed that the people of the district are very poor, and most of them have been living below the poverty line. Although the learned district judge's report is against the alleged starvation deaths, we are of the view that the happening of 1 or 2 cases of starvation deaths cannot altogether be ruled out. The petitioner number 1 laid much emphasis on his submissions on the duty of the government to take immediate steps to prevent starvation deaths, and he has submitted before us some suggestions in writing. So far as prevention of starvation deaths is concerned, his suggestions are inter alia that the government should constitute a committee of which the majority should be social workers for the purpose of supervising matters arising out of drought and other natural calamities. This committee may be called the Kanpur Relief Implementation Committee. The non-official members should not be members of any political party and should belong to well-known organizations of social work as contained in the state approved list of voluntary agencies. He has also enumerated the duties of the committee. In the circumstances, we direct the government of UP that it shall, within a month from date, nominate the names of at least 5 persons belonging to the recognized voluntary organizations and registered voluntary agencies as members of the said Natural Calamities Committee of the district. We shall accept the suggestion that the committee shall hold at least one meeting every 2 months. We are given to understand that there is also such a district level Natural Calamities Committee in the district of Kanpur. We make it clear that the government will also nominate at least 5 such persons belonging to recognized voluntary organizations within a month from today, and the committee will also perform the same functions. So far as the district of Kanpur is concerned, it has been urged by the learned Advocate General that the government of UP has already undertaken appropriate measures for mitigating the miseries of the people of that district. The steps which have been taken by the government may be stated in brief. After giving our careful consideration to the facts and circumstances of the case and the submissions made by the learned counsel for the parties, it appears to us that it is unique evident from the scheme of various subsections of section 25 of the Act that whenever an application for closure of an industrial unit is made by an employer, the state government before whom such application is made is required to dispose of such application within 60 days from the date of making the application and communicate its decision within the said period of 60 days, so that an employer does not suffer any hardship on account of failure on the part of the state government to dispose of such application for permission for closure expeditiously. In order to impel the state government to dispose of such application expeditiously, not exceeding 60 days, provision has been made that if the decision of the state government on the application for permission to close an industrial unit is not communicated within the said period of 60 days, it will be deemed that such permission has been granted. बता रहा हूँ, ये जो वर्ड्स है आपके, ये 800 से लगभग 8 वर्ड कम है, 792 वर्ड्स है, और 3P लीगल का 145 और 146 है. स्पीड में बताता हूँ एक बार आपको उसकी. 100+ स्पीड है.